Hello, we're going to talk about today legal translation and the features of the legal documents. What are the distinctive features of legal English, for example? Of course, we need to know these because this is a formula whereby they are taken from form book, i.e. these forms are actually set. So once you know them, it becomes quite regularly using them all the time. So there are some phrases, some features that distinguish the legal English, which I'm going to talk about this afternoon. One of the features is the actual repetition of lexical items. For example, the word the respondent being repeated in a document. You say the petitioner and the respondent, the petitioner and the respondent, or the tenant and the landlord, the tenant and the landlord. You repeat that all the time. You don't say he, she. You don't use any pronouns. You don't say they either. In the pronouns, you only use it sometimes, be it acknowledged, for example. It is to be paid. So it is used, but very rarely that you use other pronouns like he and she and they and we and you. Instead of that, they will have to use the parties, first party, second party, first party, second party. And they will have definitions of the first party and the second party at the beginning of a contract, let's say. Or if it's a tenant and a landlord, then it's the same thing. You will mention the definitions of them at the very beginning of the contract and you define them. So in actual fact, the repetition of saying the tenant will do this and the landlord will do that. Okay, shall usually say, you don't say will. So the first party shall pay the second party, blah, blah, blah. Or the tenant shall pay, blah, 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 to the landlord. And the landlord shall release the keys to the tenant. So basically, each sentence should have the tenant and the landlord so that there is no confusion as to who we are referring back to. So that's why there's no he and she and they as pronouns that are used usually in general in English, but not in the legal English. Another element, so the repetition of lexical items is very, very common in the legal texts. There is also the passive, the passive construction. For example, the landlord shall be paid, or the amount shall be paid, or is to be paid, or is to be raised. These are quite regular passive forms. And these constructions, passive constructions, are very, very common in order to make the document more neutral, not taking sides, because as you know that legal documents are between two parties, and of course the law is in the middle to regulate the two parties and to tell them what the law is. That's why they say the first party will do this and the second party will do that. So neutrality is because of the passiveness or passive constructions. To be paid, to be acknowledged, to be recognized, to be considered, agreed to be paid, the amount or the sum is agreed to be paid. That is usually the case. Sometimes they use at the end of a noun clause a post modifier, what's called post modifier. For example, tenant will pay the rent at the time specified. The word specified is a post modifier, specified meaning the time. So the tenant will pay the rent at the time specified, not at the specified time. So the post modifier comes after that. Also, there is also the element of delay, if you like, in the language. So for example, the tenant will within, look at this, within, now the word will, or the auxiliary will, will, within 7 days after any premium in respect of such insurance shall become due, deliver receipt for. You see, shall deliver. It's actually will deliver, but the will deliver is being split in the middle with this kind of element that is modifying. It's an insertion which is used quite common in the legal. So it says here that the tenant will, within 7 days after any premium in respect of such insurance shall become due, deliver receipt of. See, the word deliver receipt of came really at the end of, after the insertion. There's also the use of, so insertions are quite common in legal documents. There is another thing which is the use of that sometimes. And here it is like acting as antecedent, coming before. So the legal has got this variety of the relative pronoun that, as in the case of an example, an objection was taken that her application was bad in point of law. An objection was taken that, now I'm going to explain here, her application was bad in point of law. So the word that is used here, which is to explain as acting as an antecedent. There is quite another aspect of the legal language, English, legal English, is the use of the suffixes er and ee, like employee and employer, mortgager and mortgagee. Okay, these are like the lessee, the lesser and the lessee when you are actually renting something, so you can be called the lessee. Of course, the lessee is the person who is taking that land, for example. So the lessee and the lesser. This is quite common in these suffixes of er, very common in the legal language. Also, there is the use of shall. Now, there's two uses of modals, the auxiliaries, of shall and may, which are very specific to English, to legal English. The fact that shall, for example, when you say shall pay or may pay, that's quite a different in meaning when you are saying shall pay or is to pay. Shall pay means pay. So you don't need to translate it as سوف يدفع. You say يدفع. The tenant shall pay the amount of المستأجر يدفع مبلغ كذا. So you don't translate shall at all. In the case of may, however, when you say you may enter the property, or not you may, the landlord may enter the property. Now here, of course, it means يجوز أن يدخل صاحب العقار إلى عقاره, to his property, to the property. They don't say to his property, to say to the property. Why did they use not pronoun his? Because they wanted to make it neutral, and also the landlord can be, sometimes maybe he will send his daughter or a female to collect the rent, for example. You can't just say because the contract says his, therefore we can't give the rent except to his. That's why they avoid the word his and her and their, because these are not to be used in legal documents at all. There is also the use of a determiner called said and such, which is quite common. It shall be lawful for the said lord, for example. The said lord means that we are talking about a specific certain lord. And the same shall be considered. Watch this. Be considered, passive, and shall be considered to be included in the security. The same shall be considered in this security. So the words said and same are quite common to refer to in order not to repeat, you mentioned these two as it's unaccompanied, of course, with the indefinite article. You can't say such as. Each such tenant or each such agent should do this and that. Action, whatever the action is. It shall be lawful, as I just said. It shall be lawful. You see the word it. It's not very common to use pronouns, but it is used. And shall be lawful, yani, it means it's lawful. Shall be lawful means it is lawful in English. So when you are translating, you don't say shall. It is lawful for the said landlord, for the mentioned landlord. The word said means the aforementioned, the one before mentioned earlier. And the same shall be considered means the same thing will be considered for that particular person. So there is a double passive construction. Be considered to be included. Be considered to be included in this one. And of course here you can translate the passive as Basil Hatem was saying, is that, which I agree totally with, that يتم included يتم تضمين هذه. There is also the element of very long and complex sentences. You find within these sentences that there's another feature, which is the long sentences, very long sentences with very little punctuations as well, which is quite characteristic of the English legal language, is that kind of usage of long sentences with a lot of insertions within these sentences, which are little clauses that are used there. Of course, the repetition, as I said earlier, is to avoid ambiguity in the legal text so that there won't be any confusion as to who is going to do what in the legal document. So it's very, very important to identify who is responsible for what. Because there is, of course, liabilities, i.e. مسؤوليات مالية with regards to whoever is breaking the law. And breaking the law means يخالف القانون. To break the law means لا يكسر القانون, يخالف القانون. So we look for also collocations that are used in the other system, in the legal Arabic system, to reflect that. There are also things relating to the terms, the terminology, the terms that are used in the legal language and legal English, which is the French terms and Latin terms. French terms are quite common and Latin terms are quite common in the legal documents that use, for example, the word commence and terminate. These are very, there's the French and Latin, and they reflect this formality in the legal documents, and that's why they are used. In English language, when you use Anglo-Saxon, like phrasal verbs and so on, they're not formal, therefore you have to look for those Latin words in English that are of Latin origin or of French origin, because these are the ones that will be considered formal and used quite regularly in legal English. So, I mean, there is archaic vocabulary used frequently, and it's highly technical, the legal language is as well. There is also another element of a distinctive feature of legal English is the legal vocabulary is the adverbs along with prepositions and conjunction. For example, hereafter, hereinafter. Hereinafter mean listed later in this document. So when you say hereinafter, okay, you say في هذا العقد فيما بعد. ترد في هذا العقد فيما بعد. For example, hereinafter, because the word here means هذا العقد وليست هنا. herein يعني في هذا العقد. After means after now, after this point in the contract. And hereof means part of the document, or يعني جزء من هذا العقد. So here too is meaning it's بهذا العقد يعني تريد أيضا في نفس هذا المقطع من هذا العقد. So herein, hereby, all of them meaning في هذا العقد, from the word here. Hereafter it means في هذا العقد وبالمستقبل, من الآن ومستقبلا, يعني بعد هذا العقد مباشرة. Hereafter. So here means هذا العقد أو هذه الوثيقة حسب ما هي التي تترجمها, إن كانت وثيقة أو شهادة, يكون معناها here means هذه الوثيقة أو هذا العقد, و there means تلك الوثيقة وتلك وذاك العقد. بمعنى if you are signing a contract and there is another document there, so when you say therein, في تلك الوثيقة التي تلحق بالعقد طبعا. ف there means that document and here means هذا العقد وهذا. As for the archaic language, for example, I'll give you just some examples like expiration, termination, duly. These are quite common expressions used. In French, you've got the word proposal, effect, society, assurance, duly, sign, policy, entrance, rules, accept. All of these are of French origin. There are also pairs which are need to be, sometimes you translate them and they come together in English, like made and signed. made and signed حرر وتم توقيعه, تم تحرير هذا العقد وتوقيعه, يعني made and signed. Made you can't say صنع هنا. For the contract you would say made means حرر and signed means تم توقيعه. Terms and conditions can be شروط وأحكام. Able and willing, قادر أو مستعد. Right and proper means صحيح, and so on. These are sort of terms that are, I will give you the Arabic of these later on. But the Latin ones, for example, ab initio, for example, it means instead of saying from the beginning in English, you would say ab initio, which is Latin, and that is to make it more formal to the contract itself. Now there is some medieval English which is used, like witnessed, okay, or doth, or out with, which are legal words that end with a th, which is the medieval English. And it is really, this is the legal language used to make it more formal as well. So that's what's pertaining to the endings to medieval English, as in witnessed and doths. And these are quite regularly used. And there are other terms which are used, like, for example, alias and alibi. These are, alias is اسم آخر, or alibi means somebody who will witness, or a priori, a posteriori, ad hoc. These are all quite regularly used. There is another feature which is quite special for the legal is the uppercase, writing the word in uppercase, i.e. each letter in that word will be capitalized. So what you say the word in uppercase. And this is quite common. And usually this is to draw attention to because it's a main point or main verb here. Like when you say witnessed, تشهد أو يشهد هذا الشخص وهذا. So this is quite common for example, when you say this agreement, when you start the word with say this agreement and write it in capital, that is to indicate the beginning of the document. And of course, this capitalization, it gives, or writing words in uppercase, is to give it this kind of, that it is the main verb of the sentence that you need to focus upon, and that's why you write it all in uppercase. And of course, as I said before about by-in between the two parties, that is, you say بين الطرفين. So you don't need to, I mean, even though it says in English by and between, but it means بين. And this is another pair of words which come together, and they are quite commonly used there. I think I have given you some sort of a good glimpse of some of the legal documents and the legal English and the features of the legal English, which I hope that gives you some idea of how the legal English works and how it is, how its legal sentences are usually self-contained units, and they are closely, they don't actually, sentences don't link with each other as well either in a document. Each one is almost stands alone, and it's a self-contained unit, the legal sentences, and they make them very long in order to make all ambiguity very clear. There won't be any misunderstanding or ambiguity in the text at all, and that's why they do that kind of thing. I hope that you have actually benefited from today's about legal English and the distinctive features of legal English, and I will give you in the next part. I've actually spoken before about some legal terms, about how to translate them, so I hope that you have benefited well from that. Thank you.